Good morning. I want to thank you for coming out and welcome you today to our Hull & Hull breakfast for the end of summer 2011. Thank you for coming out on such a great day, and for those who are calling in or watching on the internet, thank you for joining us. We have a number of great speakers today, so we'll get right to that. But before we do, I'd like to introduce the members of our firm that are here today. We have our assistants, administrative clerks, Heather McGuinness and Elizabeth Saunders-Skov. Our law student, Stuart Clark's here today. We also have Heather Frakaskowski is here. Where's Heather? Hello, Heather. Sharon Davis, Moira Visu, Holly LaValliant, and Natalia Angelini. And we'll get right to our program to keep this moving along. We have an hour today, so we'll spend some time with this presentations, and then we'll take your questions after that, and we'll stick around to answer any questions that you may have. Don't forget to log your CPD time on the Law Society website, because this does count towards that, and the end of the year is creeping up on us, and we all have to get our hours in for a CPD in the Law Society. So let's start with David. David's going to speak on the topic of litigation administrators and representation orders, and I'll invite David to the stand.
Good morning, everyone. So in deciding on the topic for today, I wanted to think a little bit outside the box in terms of issues that arise in the practice of estate litigation and in the practice of estate administration that are somewhat unconventional. Certainly for those of us who do estate litigation and estate administration, when we think of the rules of civil procedure, we generally think of rules 74 and 75, and those are the rules, of course, that speak to non-contentious and contentious administration of estates. And, of course, the sort of bread and butter litigation we think of in the context of estate litigation, and which impacts upon those of you who practice estate administration, is the conventional will challenge. And, of course, in that situation, someone files a notice of objection. There's someone who then files a notice to object, or there's a notice of appearance, and then what follows from that is an application for directions. And the parties to the proceeding are not only the applicant executor who's propounding the last will, but the beneficiaries under that last will and anyone with a financial interest in an estate, under prior wills or on an intestacy. And so the whole process is predicated upon bringing to court those persons with a financial interest and who have some stake in what's at issue in the proceeding. What typically happens in a will challenge is that we have an estate trustee during litigation appointed, and of course that's provided for in the rules. The solicitor who practices estate administration will then step in, make the application for an estate trustee during litigation, and other than not having the ability to distribute, and other than being under the supervision of the court, that estate trustee during litigation has all of the usual duties of an estate trustee. Now let's turn to Rules 9 and 10 and what I'm focusing on today. The contrast here is all about how you conduct litigation in circumstances where it's not clear whether there's an estate or whether there's an estate trustee. So essentially you're trying to engage a fight with an estate without knowing who you're dealing with or whether there's even an estate to fight over. So it presents some challenges. Before I get into the discussion of litigation administrators and representation orders, I wanted to touch briefly on Rule 9.01. And that's the rule which talks about who is a party to a claim against the estate. And of course, in the practice of estate administration, we're all familiar that one of the very first things you do once you've obtained your appointment as a estate trustee is advertise for creditors. And this is prudent obviously, to ascertain whether there are any debts owing, as part of your job as an estate trustee is to realize the estate, the assets of the estate, and pay any liabilities. So when the advertisement for creditors is made, Rule 9.1 speaks to the fact that the executor has the authority to settle claims of the estate, and of course that's provided for in other estate statutes. The exceptions to that rule are that in a number of other proceedings, and at the outset I talked about will challenges, it's necessary that the beneficiaries be added as parties to the proceeding. And those, in addition to will challenges, would be such proceedings as interpretations, removal applications, actions against executors for fraud or misconduct, and also support claims under the Succession Law Reform Act, because the Act itself under Part 5 says that the court cannot make an order for support that would impact upon a beneficiary without them being given notice. So they have to be party to those proceedings. But when we're talking about claims against the estate and the authority of the executor to settle those claims, 9.01 of the Rules of Civil Procedure speaks to that issue. Now, litigation administrators. What is a litigation administrator? Well, essentially, a litigation administrator is someone who is appointed by the court in circumstances where the administration of justice requires that an estate be represented in the context of a proceeding, but the estate is not clear whether there's any estate assets, and it's not clear whether there's anyone who's got a will or has authority to act under a certificate of appointment of estate trustee without a will. So what the rule actually says, it's Rule 9.02. It says, where it's sought to commence or continue a proceeding against the estate of a deceased person who has no executor or administrator, the court on motion may appoint a litigation administrator to represent the estate for the purposes of the proceeding. And an order in a proceeding binds the estate but doesn't put the litigation administrator at any personal risk. So I want to talk briefly about a few of the cases that have considered issues that arise regarding litigation administrators. The first case I refer to is, in my paper, is G.B. and Fortin. And this was a case where the plaintiff commenced an action against a employee of a detention institution where the plaintiff had been resident. It was a regrettable, obviously, claim of sexual abuse made against the defendant in various institutions. After the plaintiff commenced the action, he discovered that the personal defendant that he named, against whom he alleged made the allegations, had died several years earlier. So the plaintiff made application to the court and said, look, I want a litigation administrator appointed. What was interesting about this case is that the reason for wanting a litigation administrator had nothing to do with getting damages from the defendant. The damages that were being sought were going to be collected in the event of a successful judgment from the institutions and the employer. But the employee against whom the misconduct was alleged died destitute, had no assets. What the plaintiff said is, look, I got to prove my case. The only way I'm going to do it is to be able to uncover any evidence, be it witnesses, paper documentation, anything of that nature. And so this was entirely a fact-finding mission for the plaintiff, and the court agreed. The court said in these circumstances where you're trying to collect evidence for a case and the key defendant is the person against whom you're making the allegations, then in those circumstances it's appropriate to appoint a litigation administrator. The whole problem was, well, who would the court appoint as a litigation administrator? And in most of these cases, the court's inclined to appoint a lawyer. In this case, the other defendants objected to the proposed appointment because it was an English-speaking lawyer, whereas all of the records would be in French. So that was easy enough to remedy, presumably. You just appoint a French-speaking or French conversant lawyer to act as litigation administrator. But I thought it was an interesting approach where the plaintiff in the case looked for a creative way to collect evidence in a very difficult case. In Kavanaugh and Harmon estate, that's another case that I referred to in my paper. This was a master's decision where a lot of these cases tend to be personal injury cases in motor vehicle accident situations. And so what happens is someone's involved in a motor vehicle accident. In this case, it was a pedestrian who was hit by a car. The person who hit her, she was a pedestrian, subsequently had a head-on collision immediately after hitting her with another vehicle and died. So a litigation administrator needed to be appointed for the estate of the individual who had hit her. The problem was there were no family members, there was no estate, and again, a little creative, I think, but shows you what happens in the world of personal injury litigation. The plaintiff had a claims adjuster for the insurer of the defendant's vehicle appointed as litigation administrator for the defendant's estate. And it was done without notice, which I found rather remarkable. This case dealt with the insurance company's, or rather the claims adjuster's motion to have himself removed. And his point was, look, I'm in a conflict here. We think this driver was trying to commit suicide. That limits the policy. I'm going to claim over against the insurance company. There's a conflict. So that was the problem there. The court said, well, yeah, there's definitely a conflict, but we still need a litigation administrator. The court still wants to ensure, and the process requires, that someone's appointed. The difficulty in all these cases is, and it's kind of self-evident, if there's no estate trustee and quite often no estate, who's going to want the job? There's no one to pay the person. Quite often the best available option is a lawyer. The lawyer is going to seek compensation. So it prevents challenges, but the courts tend to deal with these situations by kind of saying, we'll deal with the costs later. And by the way, you don't have any of the duties of a normal estate trustee. As the litigation administrator, you're not responsible for bringing in the assets. All you're responsible for is instructing counsel, and if there is no counsel, playing an active role in defending the claim against the estate. Justice Brown recently considered a case in 2010 where and this is more in line with the practice of estate litigation, an individual was trying to pass his accounts as attorney prior to the death of the deceased. After the deceased died, the attorney who wanted to pass accounts asked the court to appoint a litigation administrator to represent the estate. The PGT showed up and said, well, hold on a second. We think this guy's got assets. We've got the right under the the Crown Administration of Estates Act to apply if there is an estate and we want the job. So Justice Brown said, okay, we're going to stand this down, adjourn it for 30 days. PGT, you go and decide whether you want the job. It's self-evident that if the public guardian and trustee obtained the grant of probate, they would then be responsible for defending the estate against any claim. You don't have a situation where you'll have a litigation administrator separate and apart from an estate trustee. At least I'm not aware of any. And so it's what the decisions tend to show us is that the courts look for ways to ensure that estates are represented. But I think the fundamental point here is this only arises if there's no estate trustee who's stepping up, because we all know that one of the duties of an estate trustee is to defend claims against the estate. I spoke about that at the outset. And so if that's your duty as an estate trustee and there's a claim against the estate, then you're going to be expected to have to defend the estate. So it's somewhat a rare circumstance or an unconventional circumstance, but I think it's one we should all be alerted to. Every so often it arises. Now turning to representation orders. Representation orders are I don't know, a brother or a sister, if you will, of litigation administrators. Very similar kind of concept. What the rule basically says is, just bear with me for a moment. There's two parts of it, but I'm just going to talk right now about representation of deceased persons. Where it appears to a judge that the estate of a deceased person has an interest in a matter in question in the proceeding and there is no executor or administrator, the judge may order the proceeding continue in that person's absence or may appoint a person to represent the estate. So you can see from the wording, it's very similar language to the appointment of a litigation administrator. And what it is it's the difference with a representation order is it's giving authority to someone, and in the case I'm going to turn to in a second, it's giving authority to someone to advance a claim who would not otherwise have that authority but for a court order. And so the best case that I found recently that illustrates this is the claim or the case of Sloan and Fox Estate. And this was a case where the applicant to the court was in a relationship with a fellow named Mr. Moldaver. And she's in a relationship with him. He dies without any assets, except the only asset he might have is an interest in a trust fund under his mother's estate. And the interesting element is it was not a trust fund limited to his lifetime. There was an argument to be made that his estate had an entitlement to the mother's estate after his death, and it was for a fairly significant sum of money. And so the lady Sloan, Ms. Sloan, she applies to the court and says, look, there's a claim here that needs to be made by Mr. Moldaver's estate against the Fox estate. And Fox was the mother's name. The problem was nobody would act for the Moldaver estate because it was an insolvent estate. But Sloan understood that if she were to pursue this, it was quite possible that she could recover. And she had two interests. She was a beneficiary of the Moldaver estate, so that was one argument. The other argument that she had was that she was a creditor. And so the court considered whether or not she could be permitted to advance a claim on behalf of the Moldaver estate against the Fox estate. So from the advance a claim against the mother's estate by the son's estate, even though she was a creditor of the son's estate. So there's an inherent conflict there. On the other hand, she had a benefit in the estate, and she was the person who stood to gain. Justice Hoy heard the argument and made the following decision. I accept that the court should be cautious in granting authority to carry out litigation without the burden of administering the entire estate. So what she says at the outset, and some of the cases say this, courts don't really like appointing someone to look after a estate without being responsible for doing the full job. Then she says, on the very particular facts of this case, however, I am persuaded that an order should issue, pursuant to Rule 10.02, permitting Ms. Sloan to do so in the absence of a person representing the Moldaver estate. In addition to being a beneficiary, she's also a creditor, allegedly. If her application prevailed, she would not be an appropriate executor. And that's an interesting point. The judge says, fine, you can start the claim, you can pursue it, but if you get any money, you don't get the money. The estate of Moldaver gets the money. We're going to appoint an executor of the Moldaver estate, and by the way, it can't be you. But at least she gets the ball rolling and looks after her interest. The Moldaver estate is insolvent. Not surprisingly, no one has volunteered. And so in essence, the court does what we kind of ask courts to do, which is come up with a sensible solution to a problem. Clearly, someone had to start the claim. I can't imagine that the court would have said, no, you can't do it, so nobody can do it. I think another option might have been that the court could have said, no, you can't do it, but we're going to hand it over to someone else. And again, quite often, not that it generates work for lawyers, but the job could be given to a lawyer to pursue the claim as an officer of the court. Kind of tempting to think that a court might be inclined to go that route. And one of the arguments made against her getting the job was the lawyer for the Fox estate says, well, what happens when we go to mediation? Who am I going to mediate with? And the judge said, well, you'll mediate with the lawyer for Ms. Sloan. You won't mediate with Ms. Sloan personally. So the court seemed to think there wasn't a problem here. The last point I wanted to touch on is very briefly is Rule 11, which talks about orders to continue. That's kind of very basic situation. If someone dies in the course of a proceeding, you go to court, you get an order against the person's estate. Really just an automatic procedure there. But the purpose, again, of today is really just to alert everyone to the fact that litigation administrators are provided for in the rules. Rules 9 and 10 tend to get buried in there, and we don't often give consideration to them as litigators or as administrators. But the reality is that they provide creative remedies in situations where at first blush we think we've got an insolvent estate, but we still have a claim, and how we can creatively pursue it. Thank you.
Thank you. Thank you very much, David. If you have any questions, I'd ask that you save those to the end of the program, and we have microphones set up so we can take your questions. Our next speaker is Nadia Harris-Samowitz, who's going to talk about a recent Court of Appeal decision and the discussion in there with respect to whether a transfer is a gift. Thank you.
Good morning, everybody. As Paul said, I'm going to speak briefly on the recent Court of Appeal decision in McNamee and McNamee. And just so everyone has a little bit of background, I'm going to start with the lower court decision because that's where the facts, as always, are really addressed. And on this particular instance, the facts really turn in both of the decisions, and you need an understanding to be able to move forward. So the McNamee and McNamee decision, not an estate matter, was brought before the court in the family context on the separation of two spouses, and it involved an estate freeze. So there was an estate freeze that occurred, and the question before the lower court was whether or not the shares that were transferred as part of the estate freeze were considered a gift. And like I said, we need a little more context before we can move forward. So the court took a look at the requirements for a gift, and as a basic way of background, a gift is a voluntary transfer of property to another without compensation. And that seems standard across Ontario, certainly, and the Supreme Court of Canada has approved that as well. So the courts in this instance had to look at the elements of a gift to see whether or not these specific elements, as they had been articulated by the courts, were applicable to this scenario and the estate freeze and the relative shares. And the elements of a gift that the court considered was the intention to donate, the acceptance of the gift by the donee, an act sufficient to constitute delivery of the gift, and then there was also some consideration given by the courts to the possibility of a unilateral gifting where acceptance is not as obvious as it may otherwise have been, and in such a circumstance the gift can still be completed, however it is subject to the donee's right to repudiate the gift. In this circumstance, I'll go on to further describe it later, but the donee did not repudiate the gift. The court was merely saying that these are the factors, these are the elements, and there is the possibility to have that fourth unilateral gifting where there's no obvious acceptance. So the lower court decision in McNamee was heard in 2009 in Brockville, Ontario by Justice Tranmer, and he released his decision shortly thereafter in March of 2010. So we're looking at a fairly quick timeline from a litigation perspective. And the judge found that the evidence of the parties was appropriate and accepted all the evidence of the two spouses. And they had been married since 1989 and separated in 2007. So we're talking a very long relationship. And throughout the course of that relationship, there was evidence that they had dealt with everything jointly. So their houses were held jointly, their bank accounts were held jointly, and the debt was separated jointly upon separation, and everything seemed to be going according to that plan. And the judge even took note from a family perspective that the two parties were able to amicably separate all of their assets and deal with their separation in a very positive manner, subject to the two questions that were brought to the court. And the two questions were, as I've mentioned, the issue of the gift, and there was also an issue as to income for the purpose of spousal support, which I'm not going to address. But if you are practicing in family law as well, I would direct you to the case because it is an interesting analysis. Like I said, this dealt with an estate freeze, and it was a family business owned by the husband's father that the husband and his brother worked in, as well as the father. And the father made a decision in 2003 on the advice of his accountant that an estate freeze would possibly be beneficial to him for estate planning and for corporate tax purposes. And the father, which the lower court does a significant analysis of, as does the Court of Appeal, the father spoke to the accountant and advised that it was his intention to take advantage of the corporate tax benefits and the estate freeze benefits on an estate issue down the road, but that he really wanted to maintain control of the company. And in this circumstance, and in estate freeze in general, there's a separation of the ownership. So 500 shares in this case were gifted to each of the husband and his brother as part of the estate freeze. And to give effect to that, based on the father's goal that he wanted to maintain control, there was a declaration of gift. And then there was also a unanimous shareholders agreement that was signed dealing with what would happen to the shares in the event that one of the three parties, so the father and the two sons, stopped working at the company, or in the event that one of them passed away. And that shareholders agreement became of issue when there was a discussion as to delivery of the gift, whether or not control was relinquished by the father, and it really came into play as to the specific elements of a gift. So the shares, again, were controlled by the declaration of gift in this unanimous shareholders agreement, and there was a statement in the materials that noted that the increase in value of these shares was not to be was to be excluded from NFP, or so your net family property, and not just the increase, but the share values themselves. And on transfer, they had no value, so it was really a question of if there was an increase, would that be included in your net family property? And the father's instructions were that no increase, no share value was to be included on your net family property. And by way of background, the father had himself been involved in what the court notes to be a contentious separation and divorce, and as a result had this particular interest in ensuring that his sons were protected in the case of separation. Interestingly enough, at the time of the transfer, the two sons were made aware that the shares were being provided to them. They signed some documentation. The husband, in this specific circumstance, indicated that he wasn't aware of what he was signing, but he knew that his dad put some documents before him, and he signed them because his dad said, please do this. And it was his understanding that he was getting an outright 1/3 ownership in the business. And that particular question becomes of importance in the lower court matter because the judge turns to whether or not the husband's understanding of the transfer of shares impacts his ability to accept a gift. The lower court judge did find that it was not a gift and then included in the NFP, and it hinged partially on that issue, whether or not the son's understanding of his belief that he received 1/3 ownership was relevant. There was also a consideration of the fact that the husband went and told his wife, Dad's transferring the shares, I got 1/3 of the business, this is what we've been working for as a family, we're on our way. And that conversation and that acknowledgement and the expectation that the parties had that everything was joint was noted by the lower court decision and significantly contributed to, I believe, the lower court judge's analysis of why the shares were not a gift. So as I noted, the matter came up for appeal, and the Court of Appeal took interest. And in 2011, in February of this year, it was heard by the Court of Appeal, and the issue was not appealed on the family law matter. Like I said, there was the separate issue, but was only appealed on this particular share question and the gift question. And the Court of Appeal was asked whether or not the shares were gifted and therefore excluded from NFP, or if they were transferred in a different manner and therefore to be included in NFP. As I previously mentioned, the unanimous shareholders agreement and the terms outlined therein were brought up before the Court of Appeal, and the Court of Appeal said that the disposition and the understanding of all the parties there would impact the questions, the satisfaction of the elements of a gift. And then the Court of Appeal took a look at the lower court decision in respect of the elements, and they particularly took issue with the lower court's evaluation of the concept of consideration. And the lower court had spent some time from a legal analysis perspective looking at the issue of consideration on a transfer as I had noted, a gift does not require consideration. In fact, it's one of the elements. It's not one of the elements. So the analysis that the lower court had done in this respect was found by the Court of Appeal to be essentially irrelevant in this particular instance. The Court of Appeal also took a look at the intention of the donor, and which on a review of the lower court's decision, and they found that the intention of the donor, in this case the father, to transfer the assets was specifically a gift. And they looked at the fact that the father had instructed his corporate lawyer as part of the estate freeze to draft a declaration of gift and have that signed, and to make all the parties aware that it was a gift. And interestingly, in this circumstance, the Court of Appeal looked at the intention in respect of the donation of gift, but they also had to look at the intention of the donor with reference to the lower court's decision, where it was said that because the donor intended to effect the estate freeze for corporate tax purposes and not necessarily just for the purpose of gifting, there was an issue there that the lower court determined the gift was not the intention, it was the corporate tax freeze or the corporate issues that was the intention. And the Court of Appeal found that the lower court was confusing the concept of intention with motivation and purpose. And interestingly enough, right? The Court of Appeal looked at it and said the intent of the father was clearly to gift. It's evidenced by the donation to gift, and it's evidenced by the transfer. His motivation and background doesn't have to be the primary focus. It can be there, and it can be in existence to do the corporate analysis and have the corporate benefits, but it doesn't necessarily have to be a single purpose of gifting to make it a gift. And the analysis basically ended up with, although the ultimate purpose may have had multiple facets, the intention to gift was still there, satisfying the first element of the gift test. The issue of delivery in this circumstance was not really at issue. The transfer was clearly made. There were share certificates, and there was no question on any of the parties' sides whether or not delivery had been satisfied. So the next test element that the Court of Appeal looked at was the issue of acceptance. And the lower court, as I had mentioned, considered the 1/3 interest that the son had believed he received to go to the issue of acceptance and whether or not the son had indeed accepted a gift as part of that element. The lower court, as I mentioned, found that it was not a gift and therefore part of NFP, but the Court of Appeal took an interesting view and specifically went through the issues of the father's control of the shares, part of the unanimous shareholders agreement and part of the control that the father maintained as per that shareholders agreement, and noted that despite the father's control, the son had accepted the gift. He continued to work with the company. He had the shares transferred to him. He knew that the shares had been transferred to him, and the court found that despite his misunderstanding, it didn't impact his acceptance of the gift, which, as I'm sure you can appreciate, could have interesting applications in a variety of gifting transfers in an estate matter, because the court was saying that the acceptance of the shares didn't require him to truly understand the nature of how the shares were held. I think that probably gives you some context in terms of how the court analyzed the elements. It's a very complicated and detailed analysis, but it's well thought out and well prepared by the Court of Appeal. And like I said, the Court of Appeal overturned the lower court decision and found that the transfer was by way of gift, and that on that basis it would not be included in NFP. And in a regular context, I'd be picking up my materials and going back to my chair and saying, "Have a nice day," and that's a great finding. But in this particular case, there's a lower court decision that didn't address one of the claims that was brought by the spouse in respect of constructive trust and unjust enrichment. The wife's argument was that even if it is a gift, I have a claim on those funds by virtue of a constructive trust and unjust enrichment because I contributed to the family and I supported my husband. And the lower court didn't actually address that at all because the lower court found that it had not been a gift, and therefore she had a claim and it was part of NFP. So what the Court of Appeal does to deal with this, it says there's not enough facts in this decision for me to, or for us to actually give you an answer on the constructive trust and unjust enrichment claim. They send it back down for trial, which certainly we will be hearing from hopefully shortly. And perhaps you'll see me again in the next couple of months in another breakfast series, giving my opinion on what happens in the lower court on the trial level. But for now, the elements of a gift have been clearly articulated by the Court of Appeal. They've been upheld. And I think as estate planners and estate litigators, we have a clear understanding now of the elements of a gift and how the Court of Appeal is going to be looking at them in the future. The estate freeze concept has also been very well laid out, and the elements of that have been articulated by the Court of Appeal in respect of how it's going to interplay with a gift moving forward. So I think this is a very helpful case, and I think that moving forward we're certainly going to be paying attention to see whether or not the constructive trust unjust enrichment application of the facts in this circumstance will be further impacting the estate bar and family bar as well, for sure. So I think that's it. Thank you very much.
Thank you very much, Nadia, for that gift of knowledge, which we will gladly accept. I now turn the floor over to Ian and Susanna, who are going to scare us with a number of ethical issues in the solicitors' estate planning practice.
Well, thanks, Paul. We actually don't intend to hopefully scare, but throw out some topics of conversation that we have and go through on a day-to-day basis in our estate practice. We wanted just to start off, we're sort of struck by the fact that we now, well, the Law Society tells us we have to do more of this CLE in any event, but it is really becoming a much more important aspect of our practice, and it's the ethical obligations of an estate lawyer and estate planning lawyer are ones that we struggle with from a negligence standpoint quite naturally, because there's an overlap there in terms of the issues. But I was struck by recently the the September 2002 issue of the Lawyers Weekly had a great article on the struggle that judges are going through with regard to ethical issues and how they play their role, as judges in the process of administering justice, and also in the context of a mediation scenario. And Manitoba Chief Justice Richard Scott, the chair of the CJC's Judicial Committee, just spoke at and dealt with some of these issues that actually we're going to talk about today in front of the 1,100 federally appointed judges. I'm not sure all of them were there, but at the OBA. So that was sort of a neat starting point in what some of the issues they're going to struggle with.
And what I thought was particularly interesting about the whole article was the reference to the fact that judges who are conducting these mediations are very concerned about this perception of their need to be impartial or to be viewed as being impartial. So judges who sit on benches and make decisions have to be seen as people who are hearing both sides of the story, not bringing any preconceived notions to their decisions. And yet, when they're doing mediation, they're doing very different kind of work. And I know certainly, many of us as practitioners who will do the litigation will sometimes do the mediation as well. And I don't think that kind of concern has ever crossed our minds. But it was really sort of struck the timeliness of this whole topic about ethical considerations and judges actually struggling with the fact that they might be perceived during their day jobs, so to speak, when they're back on the bench as perhaps being impartial because they've conducted mediations for people.
So now bringing it out of the lofty world of judges and how they're struggling with ethical obligations, there's a great article by Philip Slayton in was the September 2010 Canadian Lawyer magazine, and he talks about even the broader obligation, and we want to talk about some of the broad obligations and start working down and drilling down to the specifics, but the broader obligation, his view that there's a fundamental ethical obligation of every Canadian lawyer to promote and protect the rule of law. And so with that sort of onerous task ahead of us, let's start drilling down a little bit on these issues in the context of estates and trusts law. Starting with the rules of professional conduct, the first rule, 2.03, that we want to talk about, it may not be the most important, but it is the most timely in our view because it talks about the question of confidentiality. And the rule itself provides that a lawyer at all times shall hold in strict confidence all information concerning the business affairs of the client and so forth. This duty of confidentiality is fundamental and ties closely with our obligations and our duties in respect to solicitor and client privilege. And coincidentally, not that I planned it, but the decision of Justice Brown came out this week on this very point and gives us some really interesting talking points in the context of this fundamental obligation. And as I say, we're naturally inclined to think about the privilege issues when we've got a solicitor's estate file in our hands, but we can't forget the overlay of the duty of confidentiality. And Justice Brown, in the decision, which we've included in our paper, so that was handy that it came out earlier in the week, Justice Brown talks about, it's the decision of the Bayan estate, talks about a scenario which many of us who practice estates law run into, and that is what are our ethical obligations in the context of releasing the original will. And this decision, while it doesn't make any new law, really does highlight what the steps he thought he'd write a decision on, although it was on a consent basis. He thought he'd write a decision to help sort of clarify the law, a law that was has been around really easily clarified since about 1927 by the Stewart and Walker decision, which he talks about, and then was beefed up by some subsequent decisions. So let's talk about the Bayan case for a minute now, Susanna, and how it deals with this specific issue of releasing original wills in our will file and how it impacts on Rule 2.03 of the duty of confidentiality.
And I think the best starting point really is just to sort of look at the facts of this case, because when you hear the ultimate result, most of us go, well, yes, of course, that's why we draft wills, so that they can be relied on and estates can be administered. But what had happened here is that the named executors, there was two people named. One was named as the primary executor and the other as the alternate. And the primary executor had renounced and the alternate did as well. And so the question was, well, who's going to administer this estate? And there was a beneficiary under the will who decided that she wanted to take on that role, and it was she that needed a copy of the original will so that she could put it to the court and to get that probate.
And it was a case that our firm was involved with, so we struggled with this question a little bit, and it's referred to in there where I wrote a letter, and I said to the solicitor, well, what's your concern? Isn't it sort of expected that you're going to release the original will when someone dies? And the Stewart and Walker decision confirms that. But the interesting twist here is that all of the, as Susanna said, all of the executors had renounced. So quite properly, the question was put to the court to make sure that, by this solicitor, to make sure that he was in the right, or at least was protected and hadn't breached any ethical obligations by releasing this original will in this unique scenario. I think it's clear, though, that the case law supports it, that the obligation and the expectation is that when a solicitor does a will for a client and they're asked to hold the original by the client, that there's and the cases say this, there's sort of this as an assumption that the privilege and the duty of confidentiality is being waived, and it's expected that you're to release that document on death. The case talks about the one scenario where you have what is essentially notice of something contentious, notice of something that is going beyond the existing will in some sort of contentious element, and then what do you do? And that's when we overlay the necessity of getting an order to release the documents. So with this case, Justice Brown highlights, he touches on the rule, but he specifically says, and quite properly, talks about the fact that it's important to bear in mind the rationale of solicitor and client privilege and whether it's applicable. And he says the test, which is referenced in Goodman and Geffen, is to make clear that there are situations where the privilege does not arise where the parties seeking the information, party or parties seeking the information, are the same as those of the client who retained the solicitor in the first place. So it seems to me that the test there is, and in this case most of the time an executor wants to release the will, This was a beneficiary asking for the release of an original will in the face of 2 renunciations. And that test that the court has embraced for many years is that, and that as long as you're in the same, I guess, sort of in sync with what the client. And the delineation is very interesting if you get into it, because you start to think about this, well, look, who's the client here? How can a beneficiary be in sync with the client per se? An obligation of an executor is to essentially cash the check. I mean, the concept is you do a will, you give it to the solicitor, and then the solicitor releases it to the executor to go cash the check, so to speak, to distribute the assets of the estate. But does that mean that you're allowed to just simply hand an original will to a beneficiary? And the question, I think, is answered clearly in the Supreme Court of Canada decision, and that is no. You are to hand it to those who are in the same interest as the client, and that would be the executor. And then the twist in this case, of course, is that the applicant was applying, as a beneficiary, was applying to be executor. So the court held that you should indeed release the original will to this beneficiary/executor. So anyway, I mean, it's was a carefully considered decision in a relatively unique scenario when you have these renunciations, but not very unique when we are reminded of the importance of how we're going to deal with these original documents. The underlying part of this, though, is, which we don't get into, and we wanted to spend a minute on, is what is our obligation in terms of, in the context of the duty of confidentiality and privilege, but confidentiality, in terms of the underlying file documents. If we've got a pretty clear message that we can release the original will in a non-contentious or circumstances where there is no threat of any proceedings, that's now clear with the Byon decision and others. What about the underlying documents in our will file?
And I think that's a very practical concern that arises in many cases when you've got a situation where, for instance, there is no litigation, so to speak, right at the outset. It's just a matter of seeking clarification, perhaps on an interpretation of a provision of the will. What exactly does that provision mean, or what was it intended to mean? And then in those cases, the question is, can the executor go back to the drafting solicitor and say, can we see your file? We just want to see what was it that you guys discussed, what was ultimately intended when a particular word was used or a particular phrase was crafted. And we do struggle with that. Certainly, as practitioners, it's a difficult question because from a negligence perspective, we know we've got to maintain the duty of confidentiality and solicitor-client privilege, and yet at the same time, as humans who want to sort of protect ourselves in our role as, the drafting lawyer or the administrator, we want to make sure that if we are releasing this information, we're doing so properly.
So the answer exactly lies in, again, this Goodman and Geffen approach, is the underlying documents behind the will itself, the original will itself. The person who asks is the test in every respect. If you're the right person asking for the documents, you get them, is what Geffen says. Because if your interests of the party who are seeking the information are the same as the client. Well, if I'm an executor and I have to propound a will, I am entitled to I'm in the interest of the client. Now, having said that, we're not sure, and we typically will run into scenarios where we will simply get an order to release the documents so that there's no struggle with the lawyer who's holding the file. And Justice Brown in paragraph 25 says, in my view, a solicitor should only insist on the securing of a court order for the production of the original will where some reasonable basis exists to question the authority of the person making the demand for production. If no such reasonable exists, then they should be the documents should be released. He doesn't speak to the underlying documents in that, and I think purposely, because it simply doesn't seem to be the law that you're entitled to freely release the underlying documents within your will file. So that really, I think, flushes out a good illustration of the duty of confidentiality and the importance of how we manage our will files in terms of taking our instructions and what we do with our will notes and so on. The next part of again, we could talk about these rules, and there's lots of components to them, but the other part of Rule 2 that we wanted to talk about today is Rule 2.01. And that rule deals with the question of competence and goes through the ethical elements of competence. And that's where this overlay and the crisscross of analysis comes in terms of how we balance our ethical obligations and questions of standard of care and negligence. We are we are constantly bombarded as state lawyers with what courts feel our standard of care is, our expectation in the context of negligences. But we're not often thinking about the other element of it, and that is the question of competence. Because why this seems to me to be so important is that, fine, we want to protect ourselves and we're going to talk about what how the negligence issues have been playing out, but we want to protect ourselves, but we don't also want to be in front of a Law Society hearing on the question of competence. We can be found to have been negligent for taking instructions without taking notes or some easy illustration like that. But we can also be exposed to a Rule 2 competency hearing in the context of an estate practice if we haven't met that standard of care. Arguably, we could be also facing some sort of proceeding with our regulatory body. So we wanted to spend a few minutes with that, because that in and of itself means that's just as important as a negligence claim. Nobody wants to have the headache of dealing with a competence allegation in the context of the Law Society. So looking at Rule 2.1, that's how we as state lawyers are being exposed to that other layer of I guess we'll call it what it is, attack in the sense.
And when you look at it from, as you say, the negligence perspective, when we're talking about the standard of care, it's, when you look to the cases and how we're being judged, we have to be reasonably competent solicitors, or ordinarily competent solicitors, or ordinarily prudent solicitors. And those seem like very nefarious kinds of concepts in the sense that they're so fact-specific, and what have you done, and when you're being judged with the benefit of hindsight, is what you've done sufficient? And, if we break that down a little bit in terms of, taking the Rule 2.01, as Ian says, of competence, and then looking at how it is that the case law is interpreting what it is required of us, we know that there's a duty to be skillful and careful, to advise clients in all of the matters that are going to pertain to our retainers so that they understand the nature and the scope of that retainer. We know that we have to protect their interests. We can't have any conflicts of interest that are going to put us in some kind of a conflict with our clients or what it is that they want to do. And we know that we've got an obligation to carry out their instructions by all proper means. So how do we do that as practitioners is the real question, and how are we going to be judged after the fact as to whether or not we've met the right standard is really what we struggle with.
And these are ethical duties. They're not necessarily negligence duties. And I know that we may be splitting hairs here, but again, we're looking at two prongs of attack that can exist here. And these ethical duties come out of Rule 2. And if you look at Rule 2 and the commentary on Rule 2, they in fact highlight that element of it. And where you see it is these ideas of protecting interests of the client. Well, Rule 2 in and of itself talks about conflict of interest as well, or duty of confidentiality, or those elements of the rules of civil procedure are all elements of the negligence standard of care. And even just looking at it, one of the things that we've added to our checklist when we're taking difficult instructions is, what relevant case law have we considered in the context of capacity is an element of the ethical obligation. You have that ethical obligation to be current. And if we're being current, then what kind of elements, what relevant case law have we considered? So just for that illustration, the easiest one, and we think anyway, one of the most sort of demonstrative or helpful decision is the Rosenberg estate, which is a current sort of analysis of what we are expected at the level of the negligence standard of care, but it also, I think, understanding that case allows us to meet and exceed any of the expectations from our ethical standards that are set out in the rules. So let's just talk for a minute about the Rosenberg decision.
And we've got that in our paper at page 6 in terms of the sort of the 6-part test that the court looked at when it was examining whether or not a lawyer was acting reasonably competent when it came time to the issue of how long he had to draft a will in the circumstances that were facing him. And I think the case was very instructive in the sense that it recognizes that certain cases are going to call for tighter timelines, and other kinds of cases are going to be perhaps less tight of a timeline or less of an urgency to it, and it's all going to depend on what it is that the solicitor is faced with when they're meeting with their client in those particular circumstances. And I think that's helpful because it's so easy for us to say, 7 days is plenty of time to put together a will. but maybe it isn't. And the court in this case was actually cognizant of the fact that, yes, there are certainly expectations that arise because of certain circumstances, the client's particular circumstances, their health, their urgency, but there's also the reality of the fact that we as solicitors are humans, and we've got lives that are sometimes more than just our practices. And so when you look at it, we're looking at the 6 parts, and there's the terms of the retainer. Was there a precise timeline that was actually agreed upon with the client? So the judges are recognizing, yes, this is important. We've got to know what the expectation was of the client.
And just identifying that, again, cross-referencing that to our competency, timeliness is a foundation of the competency expectations and the rules. So if we are found to be, if a lawyer is found to be negligent in terms of his timeliness, you presumably could be exposed to having not met the standard of the ethical standard under the rules of conduct. So, again, what we're trying to do, in some respects, maybe there is a scary element of it to our practice because it's another wing of attack. It's more, from our perspective, an analysis of where are the negligence cases taking the ethical questions. And, the Rosenberg decision helps us in that regard. The White and Jones, obviously, is the classic. You've got they gave about 6 weeks to do your will. There's a case in England that talks about 7 days to do a will. There's moving targets, but the Rosenberg case really helped us at least identify whether we're current on the law, A, which is an ethical expectation, and B, what are some of the parameters of the analysis. So just to finish off, but before we end our talk on this, is sort of a bit of an overview, an issue identifier that we see touching on estates and our ethical obligations questions. And identifying, first of all, are we in a non-contentious retainer scenario, or are we in a semi-contentious retainer scenario, or are we in a contentious retainer scenario? And I know all of us like to have a nice administration land on our desk and walk through it and do everything right and distribute the estate with a happy clearance certificate in a timely way. But even those cases, an administration case can be a contentious retainer, or can be a sort of mini contentious retainer. There might be elements of it. So where do we see the ethical Rule 2 issues flaring up in those 3 scenarios, is we just want to talk about briefly.
And even apart from the administration side of it, just right from the get-go and from the planning perspective, we know that many times we're dealing with multiple clients. Many times we're dealing with husband and wife retainers. And just that kind of arrangement in itself is going to raise, these duties of confidentiality, of avoiding conflicts of interest. And the rules specifically speak to the joint retainer situation when you're drafting wills for spouses, because commentary has just recently been added to address that specific fact, because there was a recognition that we are struggling with how to deal with those situations.
And the last point is, in a contentious moment, is where we always struggle, because clients look at us sideways when we say, well, look, we're in a conflict. We can't act for you in your fiduciary capacity and in your personal capacity, if you have a personal interest versus your obligation to remain neutral. And we say, you've got to get another lawyer involved. We're always faced with this sort of quizzical look from the client saying, well, wait a minute, what do we need another lawyer involved here? And sometimes I will actually, to help illustrate the importance of it, I will just go to it and I'll say, look, our rules of conduct require, we're compelled to make sure that we don't preserve or do anything. We do everything we can to avoid a conflict of interest. This is an obvious conflict of interest, and here it is, and here's why. So it's actually can be a helpful tool, the rules themselves, to help, sort of illustrate to the clients, and maybe in plain English, because they are relatively plain English written, to help sort of manage the client's expectations when we're dealing with them. So this has just been a summary of some of the things that we've seen in our practice, direct illustrations, and of course that the buy-in estate decision helps us sort of see where it's interplaying, and it's as current as we can. So we definitely met the standard of being current. So thank you very much for your attention. We're here. We can take some questions, and but we'll also wait around, and if people want to come up and ask questions, that's fine too. So thanks very much for coming today, and we look forward to seeing everyone at our next breakfast.
Thank you. And if anyone does have any questions, please just come up to the mic. Thank you.
Ian, I had a recent situation where I had the executors all renounced. But my problem, well, I should have had that problem too, but I didn't really address it the same way the case you did. But what about your beneficiaries? How do you tell those, you're the person with the will, how do you tell those beneficiaries they're even in the will? And my beneficiaries in this case were overseas. Had no idea they were put in the will and had to be notified in some fashion because my executors had all renounced. So what do you do with something like that? They don't even know to make the application if you don't tell them.
Thank you, Vicki, for that almost impossible question.
Well, I'll tell you what I did.
Yeah,
I wrote a letter to the beneficiaries.
Yeah.
I told them that they were in the will. I provided them with a copy of the will and told them they had to get legal counsel.
Yeah. And that's
practical.
Yeah.
But I'm listening to your case and thinking I probably needed a court order to do all that.
Actually, I think what you did was exactly what Justice Brown is saying in his decision, which is that we've got to use a little bit of tempering of some kind of
Common sense.
I don't want to say common sense, but that you read between the lines, and it seems to me that that's exactly what he's saying. And it's all premised on the fact that it's the last will and testament. No one's suggesting that it's not, and so there's an expectation that that document becomes a public document, and that privilege is waived because that was the purpose of the document. So I'm subject to any comments Ian, of course, has. I think you did exactly the right thing there.
Yeah, no, and I think that's I've done it where I've actually had I've sort of begged the renouncing executor to say, could you just write a letter to everyone and say you're renouncing and tell them that they should look into this or something even vaguer than that. But that is perfectly. I mean, I think it's a helpful decision, the Buying case. I mean, it says you can release these things, and he gives it clear parameters of when you can, and so that is actually the decent thing to do as well. It's not only ethical, it's decent because otherwise, otherwise it's in limbo, and it's a situation where the administration would just linger for. Eventually, I've always found, and I touch wood, it's always worked. I find that where money is there, it almost always people figure out and they float to the top, but it wouldn't have been a timely administration if you'd been quiet. So it's funny how that attracts it, but. Morning, Bill.
Yes, Ian, and good morning to you and Susanna. And just referring to the joint retainer in your material, which I understand, I agree, I acknowledge you didn't address. But in paragraph 1, wouldn't you specifically designate or stipulate just what the retainer refers to in terms of a state administration or the specific matter?
Yeah, absolutely. That's a good point, Bill. Delineating and specifying the nature of our retainer is crucial.
And another brief administrative question. Certainly, having attended many of these sessions in the past, it's worth more than half an hour of professional development time. I'm just wondering what we can do as attendees to agitate to the Law Society to increase the credit.
I'm a big fan of agitating the Law Society. Hey, we got the special credit this time, didn't we? We got the extra one for the
practice management.
Practice management, so that makes it even more fun. Any other questions? Well, thank you again, and we look forward to seeing you either or watching next time.
Thanks, everyone.